Welcome to a community update from the Department of Senior Affairs. I'm your host, Ed Nunez. Today's topic of the show is legal basics, and with us to discuss that is Lori Millet, who's an attorney of Master of Laws in Elder Law. Lori, thanks so much for being our guest.
I'm happy to be here.
I think we talked about, you were a guest on Dirk Gray's show, Gray Matters, about 2 months ago on 770. And when you were talking about powers of attorney, it really kind of struck a chord with me because our show is based on senior affairs and senior issues. And there's so many things with power of attorney representation, documents, so many things that come up when people, pass away. And there's other things in here too. It's not just that. But I thought when I heard you, I thought we better get you on because there's so many issues that sometimes people put off until it's too late. And
Right.
And that's the sad part. We're all inevitably going to, John McCain said this on TV the other day, that every life must end. He said that, and he's facing cancer, and I thought it was a great humble statement, but he's not wrong. And we have to think about what are the legal ramifications for loved ones left behind. So that's one of the reasons I wanted to have you on. And, I guess the first question I wanted to ask what are powers of attorney?
Powers of attorney are legal documents that you sign appointing someone to represent you. In New Mexico, we have 2 different statutes governing powers of attorney. The first one is the Uniform Healthcare Decisions Act that governs medical powers of attorney. And the second one is the Uniform Power of Attorney Act that governs financial decisions. So you really need to have 2 because the combo form of power of attorney that allowed you to give someone the authority to make all those decisions was superseded by the Uniform Power of Attorney Act in 2009.
Okay, now when you say that, you're an attorney, Lori. You understand these matters. There's people out there that don't. I don't know if you can explain it more in layman's terms.
Sure.
Because you understand these documents like the back of your hand. There's other people out there that are like, what does she mean and what is she talking about? Because what do I need to kind of do to maybe get if I pass away, we'll talk about wills, because I think that's important too. But what does she mean? What forms do I need?
You have to have 2 different forms. You have to have one that nominates someone to make all your financial decisions, pay your bills, sign a contract, and those kinds of things. And then you need a second one that's just for medical decisions. I also recommend that the one for medical or healthcare decisions contains a section about mental health decisions as well.
Mental health decisions. What do you mean? Okay, what do you mean by that? Because you hear these things on TV all the time. Someone was granted power of attorney, and they made decisions based on, I guess I guess they got together with the doctor. But you hear so many horror stories sometimes about decisions made by the power of attorney, who is a power of attorney though. So what do you mean by the medical part of it legally? I guess. So what do they need legally? So
there's a difference between a guardian and a power of attorney, and at this moment, I'm not talking about a guardianship, which is what has been focused on by the media a great deal this year. A power of attorney is something that can keep you out of court, which is what everybody wants. That's certainly what I want for my clients. I don't want them to have their families file a guardianship case in district court. They're expensive and they're traumatic a lot of the time, but often they are necessary. A power of attorney is a revocable document that you sign nominating the person of your choice to make decisions on your behalf. For financial decisions, the most important thing is to choose who is really going to pay your bills and not take your money. Do not choose a child who is the oldest child just because he's the oldest child. What if oldest child has an alcohol or a gambling addiction? You don't want him paying your bills, right?
Right.
So choose the most responsible child or if you don't have a responsible child or no children at all, choose a friend, or there are professionals who will make these decisions for you. For medical decisions, it's important to choose someone who will make decisions in accordance with your wishes, not what they would want for you. And sometimes that is a point of contention in families because not everyone agrees on whether or not mom, who has Alzheimer's disease, should have that surgery. Whether or not mom should go into a nursing home versus stay at home with the kids. So you want to choose the person who's going to make the decisions that you have made while you were able to do so. Does that make sense?
Well, it does to me. You know, again, you've touched on a lot of things. It's funny because when my mother and father were alive, they made me the power of attorney when I was 9, and I'm the youngest. This was when I was 19 or 20. And of course, back then, you never think your parents are going, you don't think about that day at all. Then my dad passed away, and then my mom, passed away last year at the age of 91. But I don't think anybody thinks about those, decisions. And I kind of always wondered, my brother and sister are fine, upstanding people. It's kind of weird that they named the youngest, but at that time my brother and sister were living out of state. They live back here in Albuquerque now, so maybe that was one of the reasons they did. But I was the youngest. It was kind of strange because, I wasn't married. I didn't, have a lot of responsibility at that time. And both my brother and sister did more than me. They were older than me.
Maybe that's why. Your brother and sister had more on their plate than you did. And so your parents figured you had the time, whereas perhaps they didn't.
Right, right. And I think one of the things you say, though, and these are important, again, I think I want to ask you when you say that there will be people that will make those decisions for you, because there's a lot of people that may not have anyone that make those decisions or to help them, or they don't have any kids or anybody. So then what happens? And you said somebody would help you. Can you explain a little bit about that?
There are professionals who will act as your power of attorney. Some do it for medical decisions. Some do it for financial decisions. Some companies do both. So there are a number of professional, they're called fiduciaries, professionals who will make those decisions for you. And you need to talk to them and make sure that you have a connection with them. Tell them what your wishes are and make sure they know where your bank accounts are, where your important papers are, so that in the event you are unable to make your decisions, they will be able to step into your shoes with minimal fuss.
I think that's an important thing, too, is that the important papers, where are they? I mean, maybe you want to touch on that because there's power of attorneys. I was a power of attorney, but I remember I had to go look for it, and I kind of knew where it was. But again, I wasn't thinking. My mother had just passed away. Yes, she was 91, but that wasn't something that I wasn't looking forward to. So I wasn't like, oh, I know where it's at. My mom would tell me, it's time for me to go. She'd say, and I'd say, Mom, look, my brother and sister, we're not calling each other every day to see, is it time? Does it happen? We weren't even thinking about that. So I think that's another thing is, security of papers and where are you going to put these things? Where will they be? Things like that. I'm sure that's an important topic as well.
So I recommend that you give the people that you name a copy of the power of attorney so that they have a copy in case they are called upon to act on your behalf. In New Mexico, copies of powers of attorney are just as effective as the originals by law. So you never want to give up the original because there are some financial institutions who want to see the original to make sure that it hasn't been tampered with and make their own copy. But it is very clear law that a copy is just as effective as the original.
Okay, that's so important. I think when you're saying that, because these legal matters, one of the things is when I started making decisions for my mother, they wanted that copy right away. Where's the copy signed? It had to be notarized. So there's so many things that are important in the state matters and things like that at the end of a person's life. Mm-hmm. So I think you're bringing up a lot of good points there because if you don't have your paperwork in order, it's not as if you can just say, well, my brother and I had gone back and forth. It wasn't official until my mother signed these papers. In other words, they would ask when my mother was sick and had a heart attack at 85. She came back from that. She came back. But they would ask who's the power of attorney. My brother would point to me, but there was no papers indicating that I was. Big difference, because then you had to go file them. My mother had to sign them. Again, we weren't thinking about that, and we did get it done, because it could have been a mess when if my mother had passed away without that paperwork being done. So I kind of wanted you to talk a little bit about it. You have, but how important is that?
So, first of all, I want to make sure everyone understands people of all ages need powers of attorney.
Not just the elderly.
Yeah, that's right. Not just the elderly. Because an accident or some other tragedy can happen to someone of any age. So even your younger children, my son, as soon as he turned 18, he signed powers of attorney, but his mom's a lawyer. So that was probably more extreme than what some people do. But there was a very famous case in Florida. The lady was named Terry Schiavo. And she had no health care power of attorney. And there was a couple decades long, as I recall,
oh my goodness,
court battle
yes,
about whether or not they were going to take her off artificial nutrition, hydration, because when they took her off the respirator, she started breathing on her own, and they didn't expect that. So if you want to avoid those kind of hassles, document it. The other thing about having the powers of attorney is to remember that they die with you. When you're gone, your power of attorney is gone. The wills don't come to life until after you have passed away. So a lot of people think the powers of attorney are still good when someone has passed, and they are not. So be sure that your family understands that, so that they know where all the right documents are for the right situation.
Interesting, because again, you're going through a tough time anyway. You just lost, your mother or father's case. That's one of the worst days of anybody's life,
Yes, it
losing
is.
them. So you've got to have a clear head, because I remember it took us a little while. We just settled the estate, I believe, finally closed it out. And that wasn't anything I was looking forward to, but it had to be done. It had to be done, and that's what my mother would have wanted that done, and she said that. Make sure you do the right thing, and we did. We did. What anybody else does as far as what they do, and you made that clear. Be careful in who you choose. That's everybody's individual decision. Sometimes it works out good, sometimes it doesn't. That's life. But I think just the you just saying that, and my wife and I'm 55 and my wife is 57, and we were talking about and we'll talk about wills here in a minute. But I think you're right. My son will be passing, hopefully the bar next year, and next summer, and hopefully he'll probably be telling us the same thing as far as getting a power of attorney and maybe even doing wills. We're not on the last legs, but we're not 25 or 35 either. So there's only one way to go, and that's in that way that we should develop some financial planning. So I think that's your message here is again, be sure that you get a power of attorney. You know where those documents are going to be.
Yes.
Because a lot of people, sometimes there's a long illness, Alzheimer's, dementia, and you're stricken with that. You're like, oh my goodness, this isn't what I remember. It's heartbreaking. So you're not even thinking in a clear mind anyway.
No, you're not. No.
So I think those things that you mentioned are just so important. And because sometimes if you don't get those things, oh my goodness. So you mentioned Terry Schiavo. That was, and the Supreme Court had to intervene, didn't they? Mm-hmm. Okay, so that was a 15-year, 10-year battle?
It was at least 12, 15 years. It was horrible. I don't want anyone's family to have to go through that. And then their family relationship was ruined, between Terry's parents and Terry's husband. So just a total nightmare. Now, powers of attorney don't always keep you out of court. If you have chosen badly, or just as you said, life happens, sometimes things go wrong, sometimes the kids have to file for guardianship anyway. So I want to make sure everyone understands having powers of attorney is not a guarantee that you're going to stay out of court. but it is certainly the best protective step you can do for yourself.
So it might be challenged anyway.
Right. It might be challenged anyway, but particularly for financial decisions, if you do not have a financial power of attorney and you become incapacitated, your family has no choice but to file in district court because there's no default decision-making tree in the financial power of attorney statute. There is a default decision-making tree in the healthcare power of attorney statute. So at least you'd be covered somewhat. But for financial decisions, there's not. And even as between spouses, you do not automatically have access to your spouse's accounts if they're just in her name, his or her name.
Right.
So, for example, I've had to do a couple of guardianships where the spouse did not have a power of attorney and they needed to access the other spouse's IRA or retirement account so they could get the spouse qualified for Medicaid. We had to do a guardianship because there were no other options. It doesn't matter if it's community property. It matters that you have a legal representative, whether it's your spouse or somebody else. And if you have a spouse that has a degenerative or a progressive disease, it's not a good idea to name them either because the Alzheimer's, for example, is just going to get worse. And your spouse is not always going to realize they're no longer able to make decisions. So don't name them. You're not doing it out of disrespect. You're doing it out of practicality.
Right. And some people would look at it and say, family members might say, why are you disrespecting mom or dad or Aunt, Jim, Aunt Brenda, Uncle Jim? That's not what it is, because practicality matters, legal matters matter. That's why we're having you on here today. So you don't want to be, when you talk about these things, and I'm trying to unpack them in my mind of the legal issues and cases they could turn into, and might anyway, but if you do that, at least get the power of attorney, and then you're covered. And you're right, it could still be challenged, but if you don't have it, where are you?
That's right. That's right. So for healthcare decisions, just for the audience's information, the default decision-making tree is the spouse, if there is one. If there isn't one, the domestic partner, so it covers same-sex couples. And then the next class is the adult children. And it's important that people understand it is a class, so it ends up being majority rules. If you have 4 children and 2 want one thing and 2 want another thing, somebody's got to go to court because the doctor is not likely to be comfortable listening to 2 children when the other 2 children are threatening to sue him. Whereas if you have an odd number of children, 3 children, then it's majority rules. So that is why, even though there is a default decision tree in the statute for healthcare decisions, you really need to choose one person at a time, at least one, and then at least one alternate, so that if something happens to the first decision maker, there's a backup. Okay,
And that's really important because you're right. It could go this way, it could go that way, but and we did have a backup. We did have a backup. If it wasn't me, we had a backup. My mother made sure that we talked about that. And some people may not even have one, but much less a backup. And I think that's why it's important again to have you on to let people know who, again, maybe in the I always say I'm in the third quarter of my life. There might be some people in the fourth quarter, and they haven't done that. And they need to because of the legal mess, and they could leave afterward. And I think the interesting thing you said is just because your spouse dies, that doesn't mean you have access to the bank. And people would say right away, well, those are my accounts. I put the money there without a power of attorney, right?
No, if the IRA is the best example because IRAs by law can only have one owner. And they cannot be put into a trust or anything. They can only be named in an individual's name. And that means nobody but that individual can access it. So you've got to have a power of attorney in order to allow someone to be able to manage that account for you.
So important. And again, I think people would think, because if they didn't have that, some would automatically think, well, that's mine too, that IRA. Not, it has to be, it has to be legally signed off on, things like that. So many things can happen at the end of a person's life, and it doesn't matter who it is. There's it could turn into again, we mentioned a court nightmare with many, and you know this more than anybody. Court fees, attorney fees, could run into the hundreds of thousands of dollars.
Yes.
So this is, again, I know I'm repetitive, why we're having you on here today. And if somebody I got your message on Dirk's show loud and clear. My ears were wide open for that, because not only for people that I work with every day, I think about them a lot. There's a lot of them, a lot of seniors that I think about, because I know that they don't have a lot, and I wonder if they plan. And again, it's not my business, but still, we do care about that. We care, and I think that's why, again, we wanted to have you to talk about this. You want to talk about the wills now? Do you have anything to say about trusts and wills? That was our next questions. One of the things that you say here in the outline, a personal representative has no authority to act unless actually appointed by the probate or district court judge in a probate case.
That's
That's
right.
one of the outlines for a will here.
That's
you
right.
want to expand upon that?
So it is a big misconception among the general public that Mom has named you in her will as personal representative, and so when she passes away, you automatically have the authority to act on behalf of the estate. No, you don't. There has to be a court order appointing you, recognizing the will, or a court order recognizing that you are the best person to serve as the personal representative of the estate, and only then do you have the authority to act as personal representative. In some states, it's called an executor.
Okay. I think that was important. My mother's will was done in 1996, and she didn't change it. There wasn't a lot of changes. She died in 2016, 20 years later. Might have been 1998. So the will itself does not transfer title to land. This must be done in that's another one. This must be done in a probate proceeding. So again,
Correct.
When there's land involved, and a lot of times there is, especially in New Mexico, man, there's a lot of land that changes hands.
Well, there is, and there's a lot of land in New Mexico that isn't very valuable. And it's important to understand that New Mexico has no exception for a $500 piece of land in Daddle. It has to go through probate too, even though it isn't worth very much.
Interesting.
So one thing I really cannot emphasize enough for the people who are watching is that I never, ever recommend you put anyone on the title to your land, particularly your home, as a joint tenant. And there's a couple of reasons for that. People do it because they think then, they won't need to pay a lawyer. They won't need a will. Because the joint tenancy designation means that the property will automatically belong to the child when they pass away. But what it also means is that your house or your land is also subject to that child's creditors. And even if it's a really good child, there can still be a car accident, and they could get sued and have a judgment entered against them. And guess whose house is going to be affected by that judgment? Guess whose bank account is going to be affected by that judgment if you put your child on your bank account? And also, what happens very commonly, and a lot of people will not believe this, but I'm telling you it's true, it happens all the time. Child tries to evict the parent from the home. Or if it's a mixed family, I'll do an example. I had a call not that long ago. Husband had a second wife. He named his daughter by his first marriage as a joint tenant on the house, As soon as Dad died, daughter kicked Mom out. And there was nothing she could do.
Wow. Yes. Again, I'm sure you see a lot of cases, and nothing surprises you from a legal standpoint. It probably used to make your jaw drop earlier in your career, and I'm sure people can be hard when it comes to, let's face it, property, land, money. You know, people can be ruthless, greedy.
It doesn't have to be a lot of money either.
Right, just the smallest amount, conniving, the whole thing. But if it's legally backed up, I was just watching, funny this morning, I was watching, one of my favorite shows is The Will. You know, I was watching James Brown Will, the Will of James Brown. And there was a lot of battle with that, with his kids and his grandkids and his supposed kids. So that was an interesting story. I didn't get to finish it, but that's actually one of my favorite shows is The Will, whoever's will. But I think what you're saying, again, you know, it's, you've probably seen it all and nothing surprises you anymore, I'm sure. But even hearing that, somebody, you know, mom kicking out, or daughter kicking out the stepdaughter, right?
Yes,
stepdaughter kicking out the mom.
Stepdaughter kicking out the surviving spouse.
And under legal ramifications, she's legal.
It's totally legal, but Dad trusted daughter, and he shouldn't have.
And again, some of those decisions later, you know, it's from the grave, you know, from the grave. I think one of the things I wanted to ask you about and point out in your little outline here, if not executed correctly, the will is not valid.
Yes.
Explain that.
So a will has to have two witnesses. It does not necessarily have to be notarized, but it has to have two witnesses. And if it doesn't, it is not a validly executed will, and the judge is likely to not accept it. You can do changes to a will. They're called codicils. And if those papers also do not have two witnesses, they're no good either. And please don't ever write on your original documents, because that can also cause the will to be invalidated. People think, oh, I can just scratch this out and initial it. No, you can't.
You got to go to your attorney.
You do.
Redraw.
That's right.
Redraft.
That's right. That's right.
Boy, that's important because, again, you know, I always say this to my son. We joke around a lot. I said, son, look, I'm not a budding attorney. You are. You know, because he'll come over there, and I love him. Me and my boy are very close. But some of the things he's talking, of course, he's in law school. We don't know these things. That's why we're having you on, Lori, because these things are, I'm not kidding, when I think about it, I'm like, oh my goodness, man, they didn't happen to us. You know, it wasn't a huge estate anyway. We've got about 2 minutes left. There's a couple more things I wanted to ask you. A copy of a will can be probated, but it is more expensive.
It is, because it's a more complicated court case. So it is definitely more expensive.
Lori, you know what? In a minute and a half we have left, you want to wrap up wills and just legal basics about powers of attorneys for us, about, again, just kind of wrap it up for us and tell the audience again why it's so important.
Powers of attorney are the most important legal documents you can have, in my opinion. And if you have a special needs child, you need to make sure that you have protected that special needs child with certain provisions in your will or your trust, because that special needs child cannot inherit from you. They will lose their Medicaid.
Oh my goodness.
And
keep going. Yeah, that's wow. I didn't even know that. Keep going.
So Medicaid is so critical, or the waiver program for some of the developmentally disabled children. They cannot inherit from you. They cannot be beneficiaries of your life insurance. They can't be beneficiaries of your IRAs. You have to make sure all that is worded very carefully to protect them.
Lori Millet, Master of Laws in Elder Law, attorney at Master of Laws in Elder Law. Today's topic was legal basics. Thanks so much for being here. You taught me a lot as well. Got to go get my wife and, of course, my budding attorney son. He'll let us know pretty soon here. Thanks so much for being our guest.
You're welcome. Thank you.
You bet. For the Department of Senior Affairs, I'm Ed Nunez.